Canada has officially enacted a major immigration law with the passage of Bill C-12, marking a significant shift in how the country manages immigration, asylum claims, and administrative powers. The law came into force on March 26, 2026, and introduces a range of new authorities for the federal government that could directly impact applicants, temporary residents, and future immigrants. One of the most notable aspects of this legislation is the introduction of sweeping reforms to asylum eligibility. These changes are designed to tighten the system and better manage the flow of asylum claims, particularly in situations where individuals may have already passed through or had opportunities to seek protection in other countries. The government aims to create a more controlled and efficient asylum process while addressing long-standing concerns around misuse and backlog pressures. In addition to asylum reforms, the law significantly expands information sharing between government departments. This means that different federal bodies will now be able to exchange immigration-related data more easily and quickly. The objective is to improve decision-making, enhance security screening, and ensure that applications are processed with more complete and accurate information. While this may improve efficiency, it also raises important questions about data handling, privacy, and oversight. A key and highly impactful provision of the new law is the authority granted to the federal government to manage immigration documents in extraordinary situations. Under these new powers, Ottawa can cancel, suspend, or change large groups of immigration documents at once. This includes documents such as visas, work permits, study permits, and electronic travel authorizations. These actions can be taken when the government determines that it is necessary to respond to emerging challenges or protect public interest. The law also allows the government to pause the intake of new applications or temporarily halt the processing of existing ones. This means that in certain scenarios, entire categories of applications could be delayed or stopped altogether. While these measures are intended to provide flexibility during emergencies or system pressures, they introduce a new level of uncertainty for applicants who may already be in the process or planning to apply. Importantly, these powers are not intended to be exercised arbitrarily. The legislation requires approval at the highest levels of government, ensuring that any major action taken under these provisions is subject to oversight and formal decision-making processes. This is meant to balance the need for rapid response with accountability. Overall, Bill C-12 represents a substantial transformation of Canada's immigration framework. It gives the government stronger tools to respond to evolving challenges, manage application volumes, and maintain system integrity. At the same time, it introduces new considerations for individuals navigating the immigration process, particularly in terms of predictability and transparency. As these changes take effect, applicants and stakeholders across Canada will be closely watching how the government uses these expanded powers and what it means for the future of immigration in the country.